Good afternoon, everybody. Like Kavya announced, I am going to give a brief case note on Novo Nordisk A S versus Union of India and others. Like the slide shows, no surprises, it is on delays. The scheme of my presentation will be such. I will start off by giving few referral points in the form of position of law and also a brief discussion of relevant case law. And then I will talk about the facts of the case, the issues, and the judgment. So the points of law or the referral points will be, like I just mentioned, in twofold. The first fold is patent rules, and the second fold will be case laws. Just to add on to the point, it will be in the form of dots. So bear with me. So dot number 1 is basically Rule 56(4). Now, the entire case of Novo Nordisk revolves around post-grant opposition, the procedure for post-grant opposition. Post-grant opposition is governed under the section 25(2), read with rules 55A to 63. I have displayed Rule 56 on the slide. I draw your special attention to 56(4), which, to state briefly, is on the opposition board's time limit to submit their recommendation, which is 3 months from the date of referral. Now, dot number 2 is Rule 57, which again, I state briefly, provides as to how the opponent has to file the written statement and also file evidence for the same if they wish to do so. Now, I draw your attention to this underlined phrase, if they wish to do so. Dot number 3 is Rule 60. Now, this is a very important dot. Now, when I'm referring to as dots, it basically means the things you will have to remember while I also explain or while I talk about the facts and the judgment. Now, like I was saying, dot number 3 is basically Rule 60. Now, to state briefly, Rule 60 states about further evidence to be filed only upon the leave of controller. I draw your attention to the phrase only upon the leave of controller. Dot number 4 is Rule 62. Now, this is one of the important dots. This is basically on the hearing procedure before the controller. And I draw your special attention to Rule 62(4), which is on admission of publication as evidence during hearing. Now, publication not already forming part of evidence. Yeah. Dot number 5.1 is the principles of natural justice, which I briefly say call as PNJ. Now, there are 3 principles of natural justice. One is nemo judex in causa sua, meaning no one should be a judge in their own cause or a cause they have an interest in. The second principle is audi alteram partem, meaning to hear the other side. And the third principle is speaking orders or reasoned decisions, forming part of the fundamentals of good administration and safeguard against arbitrariness. Now, the first 2 have come to us from the Roman law, and the third is a recent addition due to rapid development in constitutional as well as administrative law. Now, I draw your special attention to the second principle, which is audi alteram partem, meaning to hear the other side. Now, I'll be talking briefly about 2 case laws, which is Cipla Ltd versus Union of India and others. Now, this is a 2012 judgment, and I've extracted paragraph 12, unnumbered paragraph 12 on page 6 of the judgment, which briefly talks about the opposition board's recommendation has to be made available to the parties. Now, this, in short, is also part of the PNJ, which I just discussed above. Now, the second case law is Pharmacyclics Limited versus Union of India. Now, this is a 2019 judgment. I've given the relevant paragraphs to be 17, 23 to 30, 39 to 42. Special attention to para 39. Now, this entire case revolves around or details out the scheme of the Patent Act and rules with respect to post-grant opposition, and also lays down general principles to be followed during the process. Now, para 29, as it is stated, that post-grant opposition is a two-stage process. Stage 1, the process being the process before the opposition board, and stage 2, the process before the controller. Now, something to keep in mind, or something that is explicitly mentioned in this judgment, is that all documents and evidence are to pass through both these stages. Now, like I mentioned, para 39 is slightly more important in the context of the current discussion. It lays down 6 principles to be followed for post-grant opposition. First being, parties to the proceedings have freedom to file pleadings and evidence and all documents and expert testimonies as they wish. The second principle being, opponent's rejoinder under Rule 59 should only address the patentee's evidence and nothing more or nothing less. Principle number 3, once opposition board is constituted and all documents transferred to them, no further evidence is permissible. Like I earlier mentioned, Rule 56(4). Principle number 4 laid down in this judgment is, in case evidence is to be filed, then the same is to be made under Rule 60 after obtaining leave of the controller, but prior to the issuing of hearing notice by controller. I draw your special attention to these phrases, prior to issuing of hearing notice by controller, which is Rule 60, like I mentioned earlier. Principle number 5, if a publicly available document or a publication comes to light before the issue of hearing notice, then the same is to be filed along with the relevant details of publication 5 days prior to hearing. Now, this was under Rule 62(4). Now, during the hearing, principle number 6, during the hearing, opposition board members may be present to assist the controller to decide the post-grant opposition. Rule 62(1). Now, all these 6 principles are the interpretations of all the rules that I've mentioned in the brackets. And these interpretations are given by the courts in the form of these 6 principles. Now, all the dots that I just mentioned, all the 6 dots, dot 1 being Rule 56(4), dot 2 being 57, dot 3 being Rule 60, dot 4 being Rule 62, dot 5(1) being the principles of natural justice, dot 5.2 being the Supreme Court judgment on Cipla, and dot 6 being the Delhi High Court judgment on Pharmacyclics. Basically talks about how the post-grant opposition has to flow. Now, like I mentioned in the slide, notice of opposition to controller within 1 year of grant of patent has to be filed, sorry. And then the controller issues a notice to the patentee. The patentee has to file a statement and evidence within 3 months of the notice earlier, which is again an optional stage. Then the controller has to constitute an opposition board. Then the controller has to transfer all the documents and evidence submitted, filed to him, to the opposition board. The opposition board has to submit their recommendations within 3 months to the controller. Further evidence to be admitted on the leave of the controller only. Now, this further evidence may or may not be examined by the opposition board. Now, the controller fixes a date of hearing and notifies the parties not less than 10 days before such date. Now, once the date is fixed, no further evidence is to be admitted, and the entire process is to conclude within 12 to 18 months. Now, I would request any person who's listening to this to just go through this entire thing once again. Now, I'll move on to the next slide. Now, this from here on, I will talk about the actual judgment that we are supposed to be discussing in this presentation. Now, this was given by Justice Pratibha M. Singh, who is a judge of the Delhi High Court. And this was a single bench decision which came out on July 5th, 2022. This writ was filed for consideration of a representation of the patentee before fixing of hearing in the post-grant opposition. Now, the facts of the case are thus: the post-grant opposition has lasted 8 years and is still pending. The patent was granted in 2013. Opposition was filed by two opponents in 2014, 5 days before expiry of 1 year time period. There was an opposition board that was constituted, and the opposition board's recommendation came out in 2019. And that recommendation was unsigned and unnamed. The hearing before the controller was also scheduled in 2019. The patentee filed additional evidence after the hearing date was fixed. As an expert evidence, the patentee filed an additional evidence. Controller directed the opposition board to provide new recommendation based on the additional evidence that was filed. Opposition board recommendation came out in 2022. Only the name of the chairperson was there on the recommendation. Now, overall, in the last 8 years, there were 6 writ petitions filed by the parties, and the last one being on the 21st June 2022. Now, the issue and judgment of this particular case, there were 4 issues. I state 1 and 2 here. The first issue was, in the post-grant opposition, can opponent make statement without evidence? The court held yes in paragraph 30 of the judgment, and the High Court interpreted part of Rule 57 as non-mandatory. If I can draw your attention to an earlier discussion that I was just mentioning as dot number 2, where Rule 57, where I mentioned that evidence may or may not be filed in furtherance to the opposition application filed by an opponent. Now here, to decide this particular issue, Justice Singh referred to para 39 of the 2019 judgment, which is the Delhi High Court judgment of Pharmacyclics. Issue number 2, can further evidence be filed after recommendation of opposition board and fixing of post-grant opposition hearing date? Now the judge held no, it cannot be, that the further evidence cannot be filed after the hearing date is fixed, in paragraph number 19 of this present judgment. Now, the judge here interprets Rule 60 and Rule 62(4) and held that additional independent expert evidence is not publication or a publicly available document, and hence cannot be filed after the date of hearing is fixed, even after the leave of the controller. Now, the judgment of 2019, again, Pharmacyclics, para 26 and 39 were referred. Now, issue number 3 was basically, should the opposition board recommendation be made available to parties? Now, the judge held yes under paragraph 25 and 27 of the judgment. Opposition board members are to duly sign the recommendation, is what was stated in these 2 paragraphs of the judgment. Although the OBR or the opposition board recommendation is not binding, but it still has persuasive value on controller. Therefore, it is to be made available to parties. Now, the earlier judgment that I was discussing, Cipla, which is 2012 judgment of the Supreme Court, paragraph 12, which I had earlier extracted in one of the slides, was referred to by the judge in this case to decide this particular issue. Now, the last issue being mere observation of representation and scheduling of hearing date amount to representation being considered. Now, the judge held no in paragraph 32 of this judgment and stated, Deputy Controller to provide comprehensive decision on representation of patentee. Now, to conclude, I have 4 points based on the 4 issues and judgments. Parties, which are the patentee or opponent, are at liberty to file or refrain from filing the evidence for their respective statements after the date of hearing is fixed. No evidence to be filed after OBR or opposition board recommendation and fixing of hearing date by controller, except publication that is to be filed before 5 days of such hearing date. Point number 3, parties entitled to get a copy of the OBR, which is opposition board recommendation. And the last point being representation filed by parties to be heard prior to disposing of connected proceedings. I conclude. If there are any questions and comments, it can go on as comments and we will be happy to address it. Thank you.
Sure. Sure.
So Gitanjali has given the text, and I think we just want to also discuss the context behind this. And yeah, I think Dr. Kalyan, you want to take this, give us the context, please.
Yeah. So I think there has been a lot of confusion with respect to opposition proceedings over the years. When can you submit additional evidence? What will be the date of hearing that will be considered for filing of additional evidence? And would 62(4) evidence, which is in the form of evidence that is relating to publications, would it be accepted even after the date of hearing? These three questions were answered by the court. Firstly, the court said any further evidence has to be filed only after the date, or sorry, only before the date of the first hearing notice is sent. In other words, before the first date of hearing is fixed, only you can file further evidence. However, the court pointed out that if this evidence is in the form of publications which are publicly available, then that can be filed 5 days before the date of. So the court clearly differentiated these two types of evidence. So further evidence that may include publications as well as unpublished evidence can only be filed before the first date on which the notice of hearing is issued. A lot of times hearings get adjourned and the hearing may happen after 3 or 4 adjournments. For this purpose, the relevant date would be the date on which the first notice of hearing is issued. With respect to published evidence, that can be filed 5 days before the date of the hearing under Rule 62(4). Now, what remains unclarified in this judgment, though the court pointed out that the names of the members who constitute the opposition board have to be mentioned. And this was actually an issue for a long time, because a lot of times you would receive an opposition board report or recommendations, but you wouldn't know who gave those recommendations. Who were the members who were part of that opposition board. For example, in one of our recent oppositions that we participated in, names were not given, but signatures were given. And one even names were all signatures were also missing. So this practice the court put an end to by saying that the names of the opposition board members has to be mentioned not only on the title page, but also on the signature page, and they have to duly sign the same. However, what can happen sometimes is some of these opposition board members may have biases or certain other issues from the perspective of the opponent or the patentee. So therefore, it would be helpful for both the parties to know who are the members of the opposition board when the opposition board is constituted. Section 25(3) clearly states that a controller will constitute the opposition board by passing an order. But unfortunately, at this point of time, these orders are not published. And when we requested for these orders through RTI applications, they informed us that these orders are highly confidential and cannot be disclosed. Now, without knowing who the opposition board members are, we cannot object to them being part of the opposition board. And if there are any issues with those opposition board members based on the principles of natural justice that were lucidly explained by Gitanjali, we cannot bring them to the attention of the controller or the patent office at the stage of constitution in order to resolve that at that stage. So at this point of time, this aspect still remains to be adjudicated, and it would have been helpful if the court had thrown some light on this aspect. Else, otherwise, I think this judgment clearly spells out the process and also asks the patent office to decide oppositions, especially post-grant oppositions, in a timely and expeditious manner. Do you want to add anything, Gaurav?
I think one quick question, rather than to add, is when you refer to the first date of hearing, and as you already mentioned, oftentimes hearings do get adjourned, and the code is quite clear in terms of when you can submit this additional evidence, right? So let's say the hearing is adjourned, and over whatever periods of time, when you speak about filing this publication, right? Do you see an instance where let's say either of the parties, maybe the patentee or the opponent, goes ahead, makes a publication or causes a publication to be made of some nature, right? Would that be treated as valid evidence?
Well, based on the literal language, any publication, irrespective of whether that publication is by the opponent or the patentee, should be accepted as evidence. Having said that, if this publication has been made only with the intent of filtering it through to the evidence in the proceedings, through that mechanism, it can certainly be objected. But as it stands, based on the literal language, for example, let's say one of the scientists who belongs to the patentee or the opponent publishes an article in a journal which could help the same party, the company to which that scientist belongs, then that would certainly be a publication which could be adduced as evidence. But because this has been published after the initiation of these proceedings, and this was done with an intent of pushing that evidence through this mechanism, there may be objections. But generally, any evidence that is relevant based on principles of evidence and civil procedure would normally be accepted by courts, tribunals, or any other adjudicatory bodies.